It is now my pleasure to turn today's program over to Kathleen Troutman. Kathleen, the floor is yours.
Thank you. Hello, I'm Kathleen Troutman, a member of the Zurich Programs Marketing Team, and I'm pleased to welcome you to today's webinar, Scaffold Law, Liability Exposure, and Risk Management. This webinar is brought to you by Z Programs Match, which is an online tool that connects retail insurance agents with Zurich Program Administrators. It's the direct link for you to gain access to this coverage as well as more than 50 other Zurich programs. Today's webinar will run approximately 60 minutes with 10 minutes reserved at the end for questions and answers. So feel free to submit your questions at any time during the webinar by typing it in the Ask a Question box on the lower part of your screen. Today's webinar will be recorded and we will be emailing you a link to the on-demand video. It will also be posted in the Knowledge Center on the zprogramsmatch.com site. I am delighted to introduce you to our two guest speakers for today's webinar. Meg McBurney is VP of Claims and Loss Control for Distinguished Programs. Meg serves as the company's claims liaison, and she focuses on the New York Scaffold Law. Our other speaker for today is Fred Goodman, and he's a founding partner of Marion & Goodman, and has managed thousands of lawsuits and is experienced in handling insurance coverage issues and labor law claims. So now I'm going to hand the webinar over to Meg, who will begin with an overview of the Scaffold Law. Meg?
Hello, welcome everybody. I know that this topic is of great importance to your clients, and so hopefully the presentation today will shed light on what labor law is, what it covers. We'll also be discussing some of the attempted reform measures over the year, the financial impact that the Scaffold Law, labor law is also called Scaffold Law in New York, the financial impact that it has on your clients, what some of the reactions of the carriers have been in the New York market as a result, and then we're going to cover the last point, which I think will be the most helpful for you and your clients, and that is the risk management and insurance strategies you can use to try and mitigate this exposure. Thanks, Kathleen. You can move to the next slide.
Thank you, Meg. Well, I appreciate everybody attending today. Looks like we have a great participation. I'm very thankful to Meg for asking me to speak before you. When she initially asked me, I thought it was because of the admiration she had for my experience in litigation in New York and insurance issues and labor law issues, but when she honed in on the topic of the enactment of the Scaffold Law beginning in 1885, I soon realized that I was the closest person she knew to to having been born in 1885 to tell you all what took place back then and paint the picture. But anyway, with that aside, I'm sure you're all familiar to some degree at least with the New York labor law. It was enacted in 1885 and is, for the most part, has basically remained the same as a statute. Just to give you an idea of where we were in 1885, the first mass production of shoes in the United States had taken place. The Statue of Liberty arrived in New York City. Brahms' Fourth Symphony in E premiered, and Major League Baseball players' salaries were set at $1,000 to $2,000 a season. But more related is that New York City started to become the skyscraper capital of the world, such that the MetLife Tower opened in 1905. You have 40 Wall Street in 1929, the Chrysler Building around the same time, and the Empire State Building in 1930. And some of you may have seen those classic pictures of men working very high up, having their lunch on scaffolds, and why there was concern about even the legislature touching on this law. So going back to 1885, New York enacts the labor law and basically holding liable persons employing or directing others when a scaffold, hoist, stay, or ladder falls. But during the initial enactment of the statute, all the defendant, or in this case, an owner or employer, had to do to avoid liability was blame the employee. In 1887, that was amended to create a presumption of liability on the employer. But the employer still had the ability to blame the employee for liability and escape liability in that case. But in 1923, the New York Court of Appeals imposed what we know as absolute or strict liability on employers under the statute. And basically what that then means is that if you violate the labor law, you're liable. And you can't necessarily escape it as easily as you could before. In fact, in 1948, the New York Court of Appeals ruled that employers do not have the contributory negligence defense available. So they as an employer, ultimately an owner of a property, couldn't blame the employee at all to escape liability. If you violate the statute and the violation results in an injury, you're pretty much toast under the statute. In 1958, the New York Court of Appeals began even calling the employer's absolute duty under the statute as absolute liability, which sort of creates the idea that we're living with today, that if you violate the statute, you're stuck. There's very little way out of it. So there's been a lot of impact as a result of this statute, as you probably all know, and you deal with it on a daily basis. Just because the statute has been in effect, it has caused some widespread problems throughout New York, which we'll get into in a bit. But let me bring you to 1995 so you could see sort of the other side of this. New York had been the only state in the United States that had a statute like this, other than Illinois. And Illinois had so many problems with it that they repealed their scaffold law in 1995. And interestingly, a statute that was, in theory, designed to protect employees after construction workers after Illinois had repealed it. Fatalities dropped by 30% there. Injuries dropped 54%, and insurance costs dropped 50% to over 90% during a 5-year span. In 1998, the New York Court of Appeals ruled that defendants are liable when an injured worker is solely responsible for his injuries. In 2003, the New York appellate courts ruled that the law applies to cases involving falls from heights as short as 15 inches, and believe there's been some cases even at 12 inches. So as we'll get into shortly, New York Labor Law 240 concerns falls from height or providing the safety of workers who are at a height and also falling objects, which we'll get into. But you can see just how small a height can be involved. If you don't provide protection at that height for an employee, you're going to be liable if there's an injury. In 2009, the New York Court of Appeals expands the scope of the scaffold law, ruling that gravity-related accident extends beyond falls and falling objects to injuries caused when workers restrain objects. So it's not simply falling off a ladder. It applies beyond that. It's anything really height-related. So, as you know, there's been a tremendous amount of cost in the insurance industry in order to provide or at least attempt to provide the protection that the New York Labor Law requires. And in 2013, as the latest, there was major attempts, big lobbying movements to reform the law in New York and roll back or repeal the scaffolding law, and ultimately failed. And the problems that led to this attempt where the verdicts were coming in tens of millions of dollars on case-by-case basis. Local governments were paying annually $1 billion or more as a result of dealing with all the laws involved. And the premiums and deductions were high, and it was resulting in a very tightened insurance market where there weren't as many insurance companies that were willing to write this kind of insurance. So just to give you, a basic idea of, we touched on the absolute liability of this and why that's so important is, generally in New York and elsewhere, you're liable if you're negligent, if you fail to exercise reasonable care, but under the labor law, under Section 240, if you violate that statute, you are responsible. And it's very different than what other states have. So it's a unique animal of New York. And unlike no-fault workers' compensation law that I'm sure you're familiar with, under the labor laws, an injured worker is allowed to sue a third party in addition to seeking workers' compensation from their employer. So there's no limitation. There are potential deductions later on, but it won't stop the lawsuit. This slide, the best way perhaps of illustrating the cost of what's involved is, as I said, New York has the labor law. Other states don't. No other states do. New Jersey does not have anything similar to the labor law. So what you're seeing on your screen is a picture on the right side, and this was the average incurred claim costs of New York and New Jersey for joint bridge project, right? And it cost New Jersey only $10.3 million, while the same project cost New York $22.7 million, and these were all the fees incurred because of the labor law. So if that doesn't illustrate it, I don't know what does. As far as the applicability, just basic, which we'll get into more, these are fall from heights and under 240 or height related. 241 is more ground related under the labor law, and it applies to. It doesn't apply generally to single-family homes. It's usually multiple dwelling as defined, more than two, and there's certain restrictions in that as well. For example, if you're if you're a homeowner, let's say a two-family or more, and you're directing the work of others, you could be held to be required to follow the strict interpretation of the labor law. So it has an impact even in the smallest of buildings in Brooklyn, let's say. Just lastly on this topic, we'll probably get into a little bit more later too. The insurance costs are significant, as you know, and if you're a big construction company, it can maybe be absorbed in the job. But if you have a small residential building in Brooklyn, let's say, or downtown New York or somewhere, in order to go forward with a job, even the simplest of job where height is going to be involved, or other protections for workers are going to be involved, somebody has to bear the cost of that. So later we're going to talk about how to handle all that.
Okay, so next question.
Yes.
All right, so Labor Law 240. What activities exactly are covered by this law? Well, that's difficult to say in some respects and then not so difficult in others. It's really intended to cover construction activity. As Fred stated when he was talking about the history of the law, what's been considered construction activity covered within the ambit of New York Labor Law 240 has grown. What we have right now is a law that covers these construction activities: erecting, excavating, demolishing, pointing, altering, repairing, and painting. So the work that's being performed on a property has to fit into one of these categories in order to fall under Labor Law 240. Now, what type of work has the court held not fall under Labor Law 240? They've made the general statement that routine cleaning will not fall under Labor Law 240. Now, this issue has been litigated, and I can give you some examples from case law. Window washing, that is covered by Labor Law 240. However, dusting while on a ladder was considered routine maintenance and not covered by Labor Law 240. Cleaning debris from a gutter, because it was part of a regular maintenance protocol and was done 3 times a year, the court considered that not covered by labor law. And changing a light bulb, also not covered by labor law. So the courts have said that when they are trying to determine whether or not an activity is construction related and thus covered by Labor Law 240, they're going to look at the frequency with which the job occurs, whether there's special equipment that's involved in the job or specialized expertise that's needed, and if it generally involves insignificant height risk. So they look at all of these different factors to determine whether or not it is going to fall within Labor Law 240 covered activity. And next slide, Kathleen. So if it is a construction-related activity, there still are some other requirements that have to be fulfilled before the court will impose Labor Law 240 strict liability. Number 1 is that it has to be a gravity-related injury. And now Fred touched on this a little bit, but again, I'm going to give you some examples. So in addition to gravity-related injury, it has to be construction activity on a structure. Again, this is an area where the courts have expanded the view on what is a structure. So boats, buildings, fences, construction fences, scaffolding, the fences over 8 feet tall, those have all been considered structures. A tree has been held to not be a structure under Labor Law 240, so they have been able to draw that bright line rule. And then when we talk about gravity-related injuries, you hear scaffold law, and so you automatically think this has to be a fall from height, a substantial height. But as Fred said, you don't have to fall 12 stories. It can be mere inches. Courts have ruled in the employee's favor when the height, as I said, is just mere inches, and there's an ever-expanding definition of what's covered. So it's not just people falling from heights. It also, labor law has been held to cover the objects that fall from heights onto workers that causes injury. So really, you have to think about gravity-related risks. Now, another stipulation or requirement for the Labor Law 240 to apply is that in addition to being gravity-related, there has to be proof that a safety device exists that could have prevented the fall. And this is whether it's a person who falls or an object that falls. But if it's an object, further, you have to show that it's the type of object or material that would require securing. If you can do that, also show that it was gravity-related and work on a structure, construction work on a structure, then the activity will fall within Labor Law 240. So I find, again, that examples are really helpful. Let's say 2 construction workers are walking on the site. One is holding a hammer, and it slips out of his hand and falls on his coworker's foot, injuring his foot. This would not be covered under Labor Law 240. This is not a material that they would consider requiring securing. Okay, next slide.
Okay, so unlike Labor Law 240, which has the gravity-related component to it, and in which strict liability is imposed on owners and of buildings, 241 is a little bit different, and it is a little bit less, or I would say a lot less harsh but it's still imposing in its own way. It usually goes hand in hand with 240. If you see a lawsuit for 240, you generally have 241 invoked. It's more of an all-encompassing safety law on how a site is managed or constructed, equipped, arranged, guarded, for the overall protection of workers. But a good way to look at it is it's a ground level item as opposed to a gravity-related statute. The big thing that makes 241 stand out is in order to violate it, you have to directly violate New York State Industrial Code. So, for example, if there's a code section concerning a ladder, and you provide a flaw or a defective ladder that violates the code, then you can be found liable. If you don't violate the code, then 241 can be successfully defended. The Section 241, it also imposes a non-delegable duty on owners, general contractors, and their agents to provide safe and reasonable job site to those persons lawfully present. So a little bit about what a non-delegable duty means is that you can't say, I know I own this, but this contractor over here said that they were going to take care of everything, so I'm not responsible. That might not get you out of 241 because under the law, you can't delegate that duty. It doesn't mean you can't recover for what you have to pay out as an owner from someone who had agreed to, let's say, indemnify you or were really at fault for this. But it does mean you can't escape liability on that ground. There's very limited ways as an owner that you could do that, and you would have to basically be completely out of possession and no right of repair and really have nothing to do with the building, and even then that's still a tough burden. So as said, you have a non-delegable duty as the owner and a general contractor, and the duty extends to all areas in which the construction, excavation, or demolition work is being performed, and you have to provide, it's supposed to be constructed, insured, equipped, guarded, arranged, operated in a reasonable manner with adequate protection and safety to all the persons employed or lawfully frequenting the site. So as you can see, it's pretty extensive. Also, as indicated, in order to trigger liability under 241, there has to be a violation of the industrial code, which mandates compliance with a concrete specification and regulations dealing with general safety standards aren't sufficient to predicate liability under the section. It has to be very, very specific. And the reason behind it, just to give you a little background, is that construction work under the statute, under the law, is considered to be inherently dangerous. So the theory behind it is let's make owners and responsible contractors accountable for injuries that are caused, and those who have financial responsibility and the wherewithal to get the right insurance. So that was the thinking behind it. But as indicated before, it has grown greatly beyond that and has had some negative implications in insurance and just simply doing business in New York. Another big difference between 241 and 240 is that it doesn't impose absolute liability from a violation. As I said, you need a code violation, but beyond that, you're able to prove comparative negligence as a defense. So you can argue that the plaintiff caused or contributed to the accident. You can argue that a co-defendant caused or contributed to the accident, and you can limit your exposure in that sense. And one particular example of how specific the code and important the industrial code violation could be here is there was a case from not that long ago where a worker was using a circular grinder and got badly injured. And the court ruled that while a saw was covered under the code, a circular grinder was not specifically covered, and the defendant was let out of the case on summary judgment as a result. So the fact patterns of these cases are super important in defending them, also litigating them as a plaintiff. You can go to the next slide.
So I think at this point we have a poll question that we are going to push to the group. We would like to know how many of you have had difficulty placing insurance for one of your clients due to prior labor law losses on their loss run. I'll just give a minute for the responses to come in.
They're coming in. Thanks, Meg.
Okay, so while we are, actually, I'm going to give it one more minute. Do you have the responses, Kathleen?
Yep. So we've got about, Meg, 75% have responded yes, and about 25% have responded no.
Wow, that is actually higher than I anticipated. I was thinking maybe like a 60-40 split, but that explains why so many of you have called in today. And this next slide really addresses why that is. Based on data from historical and current construction projects, we know that the average value of a labor law claim is approximately $2.5 million. So that is not a small exposure. And now you've got, in addition to this increased severity of cases, an increase in the number of cases, the frequency of these cases, and due to the expanding scope of labor law past 10 to 15 years, this has had a major impact on the profitability of these coverages for insurance companies. And it's resulted in a pretty dramatic impact on how carriers view construction liability in New York compared to the rest of the country. So carriers are taking a number of actions to address this increased exposure, but ultimately we all know that the costs are going to be borne by all policyholders in New York. And not just, the cost of insurance, but really the cost of living, because when construction costs, skyrocket like this, the cost of living is also affected for everyone in New York. And so carriers are conservative. Their appetite in New York has declined due to this aggressive increase in labor law claims and awards. And in fact, we've seen in recent years, certain carriers have removed themselves almost entirely from writing any New York exposure. So not just construction, but homeowners as well. They won't write that exposure anymore. So we can go to the next slide.
Okay, so how do you handle this? How do you advise your clients as brokers, and how do building owners deal with the pain of operating under New York labor law? And there are things that you can do. Some of it is in the preparation of the work environment. And some of it is in the insurance strategies, and some of it is in the contracts that you have with various parties, whether it's a GC or subs if you're managing the job. The selection of contractors and subs should really be based on safety records. So you should have your insureds, if they're owners, try to get as much information as they can on who's going to be working there to make sure that this is someone that doesn't have a lot of claims against them and really tries hard and is reputable to provide a safe workplace. Sometimes I know that may be difficult, but it's helpful to ask. As an owner, or developer of property, as I mentioned before, we're living under a non-delegable duty situation under the labor law. You can't just pawn it off on somebody. In the first place, you're going to be responsible, even if you can lay off some of that later. So what's critical in that regard is the court's going to look at these situations is if you're supervising the work or you have control of the work as an owner, it's going to be very hard to escape from liability under the statute. So the suggestion there is, unless the particular owner really needs to be involved in the day-to-day or the management of this or the supervision of the job, the more the owner stays out of it, the better chance the owner has of not bearing the entire burden of the claim. The owner should have a written signed contract with, let's say, the general contractor, if that's how the job is being run, or a particular company that's coming in and doing some work for them. It should be signed. There are cases that do not uphold a contract that wasn't signed. And those contracts should have the proper indemnification and insurance provisions in them. You've probably seen hold harmless clauses and indemnification agreements in contracts, and there are certain ways in which they should be drafted in order to make sure that the owner is protected. It's critical. Some of the language that has been used in the past in New York hasn't helped. It just created more litigation. Now, here's an example of a hold harmless and indemnification agreement that is sort of on the better side, and it would read, to the fullest extent permitted by law, the party performing the work under this agreement, hereby known as the contractor, shall defend, indemnify, and hold harmless the property owner and property manager and their agents for whom the work is performed for any liability, loss, or other claim for damages, for death, bodily injury, or property damages arising out of performance of the work by the contractor or any agent, service employee, subcontractor, or supplier of the contractor, except to the extent of any fault attributed to the property owner or property manager. And that invokes several concepts. Sometimes these clauses are drafted instead of arising out of the performance of the work, it is if there was an injury caused by or created by, let's say, a contractor. And that requires an act or an omission by the contractor. Here, if it arises out of, it's much more broader and it gives you more protection. New York law, in its general obligations law, has limitations in construction agreements on transferring liability due to your own negligence. So if you're an owner in a construction setting and applicable under the labor law, and you have an agreement that requires someone else to be liable for your actions, to be negligent for your actions, then the statute would prohibit that. So that's why you want to make sure you have language that says to the full extent permitted by the law, and excluding any fault on your own, and that would give you a better chance of having an indemnification provision that holds.
And
the
Fred,
other, yes.
Not sorry to interrupt, but I think the really important thing to note here as well is when you're talking to your clients about labor law and the contracts, if they're going to be doing any work on their property and they come to you with questions, you know that those general contractors in New York who are doing this business, they've had their contracts drawn up for them by attorneys. They understand this labor law exposure. They deal with it every day. So they're doing everything they can to minimize their costs, their expense, their exposure. They are most likely handing your client a contract that doesn't contain any protections for them. So I think it's really important, that you tell your clients that they need to have on their side an attorney reviewing and making sure that these indemnification and additional insured protections are built in the way that New York specific law requires. This labor law, you can't do like a one-size-fits-all sort of generic language. They stick it in a contract, cross your fingers, and hope that that's going to provide the protection that your clients need.
Exactly, and what's also important in that regard is as an owner, you want to hire a contractor that has the right insurance. And the right insurance would be an obligation in the agreement to insure for a certain amount, a sufficient limit under the job, probably going to be at least $1 million, maybe much more. But also that insurance has the right language in the insurance policy. And before getting into that, as an owner, you want to make sure that this contractor coming on your property has the right policy and that you get a copy of it in advance and not simply a certificate of insurance that names you on the bottom as getting a copy of it. You want to be specifically named as an owner in that policy, specifically insured, so that if anything does go wrong on that job, there is adequate coverage. Now, you probably are all familiar with blanket coverage versus endorsement, and blanket being the more general for types of persons or companies that are covered, and endorsement would be more specific to the actual entity or individuals who are being covered. The more specific you can get, and the more sort of privity that you could establish under that contract by insuring you as an owner in a very, very clear way is what you want to make sure. I mean, that there's a lot of subtle nuances in that, but what you really want to make sure is that you have adequate coverage, and you know that you have adequate coverage in advance. You also want to make sure that the insurance that's being obtained to protect you as an owner by the contractor is primary, and that other insurance covering the property is not required to kick in unless you get to several levels. So that would protect you as an owner, not just for this particular incident, but in your rates potentially going up down the road. You also want to make sure it's ongoing and completing operations that are being covered. We've covered the arising out of or caused in whole or in part in the indemnification provisions and contracts, but that also applies in the insurance context. You want to make sure as an owner that the insurance that is being obtained, naming you in that insurance policy, is a policy that covers you basically for anything that can go wrong. So it arises out of the work of the contractor as opposed to something that was caused by the contractor, because then you're going to get into issues of whether the contractor actually caused it or not, or were fully or partially responsible or not, and then the coverage that you thought you had is going to go by the wayside. And again, I brought it up before, but it's very, very important that the certificate of insurance is real clear, and that you're not being given a policy that is essentially worthless if something goes wrong, because then your carrier is going to be asked to come in and defend you, and you need to hope that you have the right policy to cover you. And if it's a general liability policy and maybe didn't cover construction work, you might not have coverage under that policy. and then you're going to be left holding the bag. And if you're an owner, you can imagine what problems that's going to cause in your business and all around. As the broker who brought that insurance to this owner, the fingers are going to start getting pointed. I'm sure you've all seen those situations. So even though it's difficult to get the right insurance because contractors don't really want to pay for it, it's very important if you're going to let anyone onto your property to do work that you get adequate insurance, and the contract between you and the contractor provides not only the right indemnification agreement but the requirement to obtain the insurance, and then the follow-up that you actually see that insurance before the job starts. You can go to the next slide.
So the next slide deals with knowing exactly what's in your contractor's policy. We're going to discuss some of the exclusions we've seen in the marketplace in contractors' policies. But before we do that, we have another poll question. We'd like to know how many of you have been asked to interpret or review a contractor's policy or a contractor's coverage for a client prior to construction work taking place on that client's premises. So we're just going to give you all a minute to respond.
So Meg, we've got with the respondents, we've got about 92% have answered yes and about 8% have answered no.
Okay, well, for the 92% of you who answered yes, I think this information is going to be really, really helpful. And for the 8% that answered no, when that day does come, and I can assure you that it will, you're going to be prepared. So if we move to the next slide, I'm going to discuss one of the common exclusions we see on general contractor policies, and we call this the employee exclusion. So your client has done everything right. They're the property owner. They do everything that Fred just talked about on the prior slide. They get an indemnity agreement with the general contractor. They get a COI, and it shows that they're an additional insured. And so they think, great, I'm covered. Well, what happens is, as Fred discussed earlier, the injured worker can't sue his employer directly. So he can't sue that general contractor directly because workers' compensation is his exclusive remedy against his employer. But that doesn't apply to the property owner. So the injured worker instead asserts his claim directly against the property owner. Now the property owner goes, well, I'm good. I've got my indemnity agreement. I've got my contract with the general contractor. I should be able to pass this back to him, and he will bear the liability. His insurance will pick it up. Well, the general contractor gets the claim. He turns to his insurance company. He says, cover this. And the carrier says, we've got an employee exclusion in this policy. So what that means is if it's your employee who's injured that's being tendered back to you, our policy is not going to respond. This seems really unfair. It seems really unfair to both the property owner who thinks he's covered under the policy, and it seems pretty unfair to the general contractor if this isn't the insurance that he thought he was purchasing. However, the New York State Department of Insurance has looked at these exclusions. They have found them to be acceptable, and they don't think that they're misleading or against public policy. So again, it just goes to show you how important it is to know what's in your contractor's policy. Next slide. And carriers do this because if they can disclaim a labor law, claim, obviously they're saving themselves on average $2.5 million. And for general contractors purchasing this type of coverage, it's usually much less expensive than the full labor law coverage. So, whether they understand or not, they do understand the pricing is much cheaper. And, that's why they get the stripped down coverage. Now, The action over exclusion that carriers for GCs or contractors will also put into their policies is an attempt to close a loophole in the employee exclusion situation. So let's say there's a subcontractor on the job, and that subcontractor's employee gets injured. Well, that's not the GC's employee, so the employee exclusion is not going to get the GC's carrier out of liability when the property owner looks back and says, hey, cover me. However, the action over exclusion will. And basically what the action over exclusion does is it eliminates all protection that would normally be available when you've entered into this contractually created indemnity relationship. So, the owner, again, thinks that if he's got a contract that requires indemnification, the GC's carrier is going to pick up this lawsuit. If he gets sued, he tenders to the GC looks to his insurance company, and the insurance company says, nope, we have an action over. We're not picking up that contractually created liability. So again, pretty unfair to the property owner, and it's really, really important that they make sure that these two exclusions are not in their policies. We can go to the next slide. There's one more exclusion I wanted to talk about, and now this is not an exclusion in a carrier policy, but it is an exclusion we've seen in property owner policies in the market lately, and it modifies the GL coverage form via an added endorsement to the policy. What this does is it only awards coverage to the property owner for a labor law type of claim if the contractor that the property owner hired is licensed and insured. If they are not, then this policy will not respond. So basically what it does is in the exact situation that the property owner needs their coverage to respond because they either assumed that the contractor had insurance, they didn't check his policy, there's some kind of exclusion. If they are not covered under that contractor's policy and they aren't able to pass back the liability through the contractor's policy, their own insurance says, sorry, we're not going to cover it either. So what does this do? This leaves their property, their assets exposed to potentially a $2.5 million on average type of claim. This is a huge exposure. So I would really caution you when you're placing business for homeowners in New York to be aware that this is on some policies. It's a huge limitation and exclusion if the lawsuit is brought against the insured and they haven't taken the appropriate risk transfer steps. Okay, so next slide. We talked about how to mitigate this exposure a little bit earlier in terms of the contracts you need, reviewing the insurance, but just generally speaking, it's a really good idea to talk to your clients about thoroughly screening all of the contractors that they hire. What should the screening consist of? Well, make sure that you review all their references. You verify that their license is current. You review their prior complaint and OSHA history. You can even have your clients request workers' compensation claim history and their modification factor. They should require that the contractors they hire vet all subcontractors to the same standards. And if any adverse information is discovered, they really should not be hiring these contractors. So it's important to emphasize to your clients that they have to do more than just reviewing something like Yelp or Angie's List to ensure that they've got safety-driven contractors on the premises. The other thing that they can do, and so Fred talked a little bit before about controlling the work. You don't want your clients directing or controlling the work of the general contractor because that's a way that they can be pulled into labor law liability too. However, they should be asking the general contractor, is proper fall protection used? Do you do daily inspections? Do you document those inspections for things like safety equipment, ladder usage, scaffolding, hoist? Is there a formal safety training program in place for all of your employees? So while they shouldn't be providing fall protection or training themselves, or they should never be giving equipment to the contractors or their employees, they can ask these questions and ensure that these things are happening to reduce the risk or the likelihood that a claim is going to occur. And again, always get your contract in writing. Verbal agreements, we all know, are never held up by the courts. All right, next slide. So before we go into the Q&A section of this presentation, I wanted to talk to you a little bit about two programs that Distinguished Programs has created for its NYBB, New York Brick and Brownstone, package policy program. And we've done this in conjunction with Zurich. And what we've done is we've partnered with different folks to try and help property owners. So you hear Fred on the line. Obviously, he is a real expert in labor law exposure, handled plenty of these claims. So we've partnered with him in developing a risk transfer hotline. And what this means is if you're insured or your client is about to do some construction work on their premises, they have some questions about the labor law, pick up the phone, give Fred and the attorneys at his firm a call, and they can walk you through what the different exposures are. They can help your client figure out where the risks might be and really guide them towards mitigating this exposure. The other thing we've done is partner with a company called Vericlaim Repair Solutions. Vericlaim vets general contractors before they allow them onto their panel. So what does this mean? Vericlaim makes sure that the general contractors who are on their panel are licensed, are insured, are vetted. They look at their financials. They look at their workers' comp and OSHA history. And they make sure that the people on their panel are fully protected and are going to enter into contracts with your insured if they're doing work on their premises that protect them. So if one of your clients is going to be doing some construction work and they would like to hire a general contractor, they can call this number and know that they're protected. And Vericlaim will send a general contractor to check out the project, to bid the project, and if your client selects the Vericlaim contractor, they get a whole host of added benefits in addition to the insurance benefits. They get a concierge, a construction concierge throughout the life of the construction. They get somebody, that they can pick up the phone and call if they're having issues. If there's workmanship issues, Vericlaim warranties certain types of work for a number of years. So these are two things that we've created specifically for New York in an attempt to help your clients manage this exposure and make it a little easier on them. So if you want more information about this, please do reach out to myself or Fred, and we can provide you with more info. I think at this point, Kathleen, I'm going to pass it over to you.
Yep. Okay. So I just want to share with the audience just real quickly, and then we'll hurry up and get into Q&A because I know Meg and Fred have questions already in the queue for them. So I just want to share with everyone about Z Programs Match, that if you're interested in getting in contact with Meg and the team at that handles the program, the first step is to go out to Z Programs Match, and you want to go to the property category page. And when you go there is where you're going to find an overview of the owner and tenant occupied properties in New York City page, and there you're going to find the appetite guide, and that's going to give you a lot of details and information about the program that we have in place. And with the appetite guide, you're going to get a lot of additional information at your fingertips to see exactly the coverages involved and the types of risks that are eligible under the program. And then the other thing that you can do is you can request contact through there, and that goes to Meg and the team. And when you make a request for contact with any of our programs on Z Programs Match, our programs administrators are required to follow up with you guys in 2 business days, but I know Meg and her team will follow up with you as quickly as possible. So what I want to do is, as we're getting ready to do some Q&A and answer the questions that have been put into the queue for Fred and Meg, we want to ask for your feedback. And if I can have our operator just push out the survey now. It'll just take a minute. If you could give us some feedback about today's webinar, we would truly appreciate that. We do review that information, and it also gives you an opportunity if there's additional information that you would like on this topic relative to another webinar. That's something that I would certainly be able to share back with our speakers from today, and it would be something that we could develop if there was more information or a different area of what was talked about in today's webinar that you would like to know more about. And also to any other topics that you would like for webinars, we also take that information to look at other type of webinars that we would be planning for our 2019 calendar. Okay, so Meg and Fred, I know there's questions that have been submitted, so I'm going to let you guys have an opportunity to answer as many of these questions with the time that we have left.
Thank you. I know one topic, Meg, that has come up a few times here in the questions and elsewhere is there basically any chance of changing or repealing the labor law? That's a tough question. I'd start with the fact that you're talking about a statute that has basically been the same for, using my lawyer's math, about 133 years. So the chances of it just simply going away is in my best guess, is unlikely. It doesn't mean it won't be altered at some point in time, but there is a lot of pressure periodically by lobbying groups and different special interests to make some changes or get rid of the law entirely. And given the fact that New York is the only state that has this, there is some rationale for it, obviously. But again, given the length of how long this has been here, I couldn't say with any certainty that it might go away.
Yeah, we do get that question a lot when we do these live seminars, and people bring up Sheldon Silver quite a bit and, sort of rant against the plaintiff's bar and how it's controlled the legislature in New York for so many years. And periodically there are big pushes to try and reform the law, and to date all of them have failed. Which is not to say that'll always be the case, but I don't see in the foreseeable future it being restricted or changing much.
And remember,
so the next,
yes.
Go ahead.
Yeah, just the intent behind this law is to protect workers. So anytime there's a movement to repeal it or to limit it, it comes off as what's the matter? You don't care about the workers in New York. So it's a very tough argument to make.
Yeah. So the next question I'm going to respond to is, does the severity of the injury of the employee factor significantly in the final settlement? Or could large settlements be given for injuries as small as, say, a tweaked ankle? That's a really good question, and I think this is where the absolute liability or strict liability really comes into play and is so important. If you're held strictly liable and you can't present any mitigating information in your defense, all you're really left with is the plaintiff's damages case, and it can become quite difficult. Now, something like a simple tweaked ankle should not result in a $2.5 million settlement. But what's going to happen is the plaintiff is going to take that tweaked ankle. It's going to be, some kind of compartmentalized RSD syndrome that they can't walk on. And you always have the concern of the lost wage component of a labor law claim. That's really what drives the value of these up. So if the plaintiff says because of this, syndrome he has in his ankle now that he can't work anymore, yeah, you could get a pretty large settlement for what you would think is a fairly insignificant injury. And like I said, that's why the absolute strict liability makes these such tough cases to defend or mitigate your exposure on.
unlike workers' compensation, where you might have a schedule for the value of an injury, let's say, in personal injury lawsuits, you do not have a schedule. It's up to the jury to decide what the value of the damages are. But there is case law with appellate courts that give you some guidance into whether that verdict by the jury is a reasonable number or not. So you'd have to look towards the case law to decide what the value would be. So even a tweaked ankle would not be, particularly a large amount of an award. But the problem is, as Meg had indicated, because you can't under Labor Law 240 argue that the plaintiff was contributorily negligent. It's different than, let's say, you have an automobile accident and an intersection and two cars are equally as likely, and if the injuries were worth $10 but each car was worth 50% responsible, then it would be a $5 award, and that's how you would start your settlement discussions based upon who is responsible, and then use the cap of the liability damages aspect to work down from there. But you can't really do that if you're in a really bad way under 240 as a defendant.
I see we've gotten a number of questions seeking further information about VeriClaim and the risk mitigation hotline. So when we follow up, we'll provide more information about both of those programs to you. And then I think maybe we have time for one more question. Fred, do you want to do
Sure. Sure. There's been some questions concerning the applicability of the labor law, and generally it's for multiple dwellings, which is more than two family. There's exemptions for one and two family, but even in those situations, if you're controlling, supervising the work, you may find yourself subject to the labor law. So that dovetails with Meg's comments that the owner should not really control the work because they're going to open up the door for responsibility, and even in those situations, you want a contractor involved. But also, if you do have a one or a two family and you're renting that out, you're renting both units out, let's say, it's going to be deemed to be for commercial purposes, and you might still be held responsible under the statute. And there are dozens of different scenarios involved, and fact patterns that could be decided one way or the other, whether the labor law applies or not. So it's difficult to give one sweeping answer to cover it all. And it's real fact-based, and that's why you need some good lawyers out there when you have a question on this to go to, and hopefully to some case law that it's directly on point on the issue.
All right. Well, thank you, everybody.
All right. Well, we're now going to conclude the Q&A portion of this webinar. Thank you so much, Meg and Fred, for your time today. We want to make sure that everybody who attended, that you have a chance to visit zprogramsmatch.com today, and you get to see not only the program that we talked about relative to this topic, but the other programs that we have available through Zurich, and we hope you take advantage of it. We appreciate your business and your interest in the Z Programs Match webinar series. Zurich looks forward to serving you as we work together to provide for the insurance needs of our mutual customers. This concludes today's presentation. Thanks again for attending, and make it a great day.
Thank you.
Thanks to all our participants for joining us today. We hope you found this webcast presentation informative. This concludes our webcast. You may now disconnect. Have a great day.